Then there was Nathan Clifford, who was described charitably as the babbling idiot. He insisted on dying on the court, despite the fact that everyone referred to him as an out-of-control babbling idiot. And then there was Ward Hunt, who was actually speechless and paralyzed, and so could not function, could not speak or see, and remained on the court for that entire time. Now, those are just a few examples of people that were viewed as having serious mental disabilities. Justice Frank Murphy is one of the examples of, and this is 1940s, of a judge who was addicted to painkiller and would leave the court to score drugs in Washington and then come back and shoot up. And of course, Justice Rank was, his staff admitted that he was also addicted to drugs during a number of years as Chief Justice. So the court itself has had its problems with individual justices, but it doesn't have the ability to correct it. And I'm actually not sure I would increase the ability to correct it. What I would do would be to decrease the importance of individual justices. And for that, you have to look at the institution itself. And when those two justices showed up in 1790 at the Royal Exchange Building in New York, you had a court of 2, a maximum court of 6, which is a horrible number, and a court that wasn't defined in the Constitution. In fact, even though we talk about 3 co-equal branches, they're not really co-equal branches. I mean, basically, in a Madisonian system, the legislative branch is a heart, really thumping heart of the Madisonian system. But very little was said about the judiciary, and the reason is that they couldn't agree. James Madison and George Mason disagreed. And George Mason is one of the really unsold framers. I have no doubt he would be a member of the ACLU. He was the reason we eventually got a Bill of Rights. He was deeply concerned about individual rights and federalism. And he did not like Madison's suggestion that we create lower courts because he was afraid that it would rob the state courts of their authority. And so Madison did what he did so well, and that is he compromised. And then he basically got everyone to trust him. And Madison, I have to say, and I must admit I'm not a Jeffersonian fan. The Madisonians and Jeffersonians are like the Sharks and the Jets in the academic world. But Madison, I have to say, is the only framer that looks good on close inspection. I mean, most of the other framers, when you get really close to them, you're like, oh. I mean, even George Washington pales a little bit when you get up front and close. James Madison was actually the only framer that all the other framers liked. He was trusted by both sides. And that was critical because he was able to get through the Constitution on his personal funds to Mason and others, that he would design a Bill of Rights and that he promised that he would make sure that it was ratified. And his power of his personality led to the ratification of the United States Constitution. So the court itself was undefined. And that's what makes, by the way, Marbury versus Madison so incredible. Because when Marshall wrote Marbury versus Madison, he basically reconstructed the court we have today. I mean, everyone says, Marbury versus Madison is the greatest opinion of all time, even though I know of a handful of people who've read it. It's actually one of the most, anyone who's read it would never say Marbury versus Madison is the most moving, inspirational opinion of your lifetime. If you can stay awake through Marbury versus Madison, you really need to get a life. And it's a horrible opinion. It's the most boring, convoluted opinion. But the most interesting thing about it is that these self-evident truths that Marshall talked about were not self-evident. He basically made that stuff up. The United States Constitution did not say that the United States Supreme Court was the final institution that would rule on what the law means. And indeed, many of the framers assumed the opposite because they believed that they were getting something like the English system. And in the English system, Parliament plays a role in interpreting laws. And so most of the framers did not have that assumption. It was not resolved. Now, it's one of those things, by the way, Marbury versus Madison, that you love the opinion because you love the result. The fact is, Marshall was right. That's what the framers should have said. And it was one of the great bait and switches in history. And he took this really boring case, and he reconstructed the United States Supreme Court into an institution that we've all come to respect. And what's fascinating about this institution is that presidents have yielded to it, right? You had Andrew Jackson that said, John Marshall has made his decision, now let's see him enforce it. And what Jackson was saying is, where's your army? I know I have an army. Where's your army? And the fact is, the Supreme Court doesn't have an army. They have federal marshals, and in all due respect to those guys, they're not really parade ready. And, but the fact is, they've stared down every president and won in the most amazing situations where presidents have yielded. Why? Because we respect them, and we should. But the number of justices, as many of you know, is not in the Constitution. Although many citizens believe 9 members is stated in the Constitution, it's not. In fact, the numbers changed. And the actual number of 9 justices is almost, well, not almost, it's entirely arbitrary. There was never any debate that said, 9's the number. That really works well. The number of justices was set by the number of federal circuits in the country. So when you added a new circuit, you added a justice. And the reason is because justices wrote circuits. So you had to add a justice in the added circuit, or someone had to write a lot, and justices hated writing circuits. So in 1863, we had 10 justices. In 1790, we had 6 justices. When we got rid of the 10th Circuit, we got rid of a justice. And then we were left with 9. And that's how it's remained. But since the 1870s, the 9 justices became the status quo. And it's been that way for so long, it seems inviolable. Now, part of the driving force, obviously, was that justices wrote circuit. And the reason is we didn't have lower courts. So you had bizarre situations where justices would hear cases, rule on them on the trial level, and then you would hear the appeal. So they would go back and decide, was I right? And then they would rule. So the Judiciary Act of 1798 did create some trial courts, not much, but these justices were still expected to write circuit, which they hated. Because you can imagine this was very, very dangerous back then, to write circuit. There weren't any roads. You went actually through wilderness. And justices were terrified. Many justices would write letters saying, I hope that I return. I mean, they would speak of it in that sort of fatalistic sense that if I should return, God willing, I will do this or that. But there were only actually 2 states that Congress said you did not have to write circuit in because nobody in the right mind would go into those states. Do you know what they are? Kentucky and Maine. Kentucky and Maine were viewed as so backward and so dangerous that we couldn't require justices to go into those states. It has pretty much remained the same. But the fascinating thing about writing circuit is that it had a really good purpose that had nothing to do with the lower courts. And I'm going to mention this in a second in terms of my scandalous attacks on the Supreme Court. And when the justices continually asked for the writing circuit to end, and this was a huge business where the justices at one point said that they would give up pay raises, if they would just let them not have to write circuits. And one congressman gave what I thought was an amazingly interesting speech on the floor of the House of Representatives. And it was like an hour-long speech on why we should keep these people writing circuit despite all their complaints. And he was right. He said that writing circuit keeps these justices from creating what he called a fossilized institution. And said that by getting them to see real people, real cases, that they would not become fossilized and remote, how to deal with the case. And we see this all the time, particularly in the civil liberties side, where the Supreme Court totally sort of wimps out, and they give us half a decision and send us back, and nobody has any idea what to do with the opinion. And you look at this and you go, what do you possibly expect us to do with this? And it's because it's a very political institution. Well, writing circuit was designed to get them to actually hear cases. They have to apply their own doctrines, their own rules. And I think, frankly, we need that back. But what we definitely need is additional justices. During the Sanderdale O'Connor period, and I'm sure Robert can have many stories about that as well, most of us that covered the court, when O'Connor was on the court, would spend basically the summer debating how Sanderdale O'Connor felt about the death penalty, abortion, did she change over the summer? Because she was a court of one. It was a court of one. And she would change. I mean, one of the criticisms of Senator O'Connor is you have no idea. I mean, she did many interesting opinions. She was the least consistent justice in the history of that court. And I think that's a problem. She would, I'll tell you what, I'll take a consistent justice on the other side any time, because they're being propelled by principles that you can count on, you can understand. And what would happen is that we would have whole doctrines overturned. Just because we had a shift of one justice. Whether you agree or not, that's not good. And it would have horrified the framers that there was a justice with that amount of authority. In one study, in 1 year, there were 14 5-4 decisions, and she was a swing vote at 12 to 14. That's unbelievable. And that is bad for the system. So the question is, how do we deal with that? And the answer is, if you look at 9 justices, you come to the conclusion that 9 is one of the worst numbers you can have for a court. And we have a lot of experience looking at different size courts. It turns out 9 is a horrible number. And ever since we went to 9, we've had 5-4 splits. It wasn't invented by Senator O'Connor. This court has been divided 5-4 for almost half of its history. If you count all of the 5-4 periods, it's almost half of its history. Because it's a ludicrous number. Because the way we select these justices, they get calcified, and yes, they get fossilized. And as justices live longer, we're all living longer, we're all practicing longer, it stays stagnant. So those 5-4 splits remain. Now, right now, Justice Kennedy is a justice of 1. I mean, I feel stupid on TV, because every time I go on TV, I have to say, well, it depends how Justice Kennedy's going to go. I mean, it's just, on most civil liberties issues, it's Justice Kennedy. You can pretty much count the votes before the briefs go in. So, we have different numbers of courts, but we have courts of appeals. And in studying the courts of appeals, 19 is a really good number. Most court of appeals are about 19. Some are bigger, some are smaller. More importantly, we will probably have 19 circuits, or at least 17 or 18 circuits within a couple of decades, the way that it's going. Now, what benefits do you get by staying in court? Well, you get the benefits that Roosevelt wanted when he faced the 4 horsemen. Roosevelt tried to